When it comes to ideas and what copyright law says about ideas, there's a lot of confusion. So let me speak to what is known as the idea-expression dichotomy. Another fundamental principle of United States copyright law is the idea-expression dichotomy. To the framers of the Constitution, a specific creative expression necessarily divulges ideas that can and should be freely used by the public. That is to say, the framers understood that after a creative expression is divulged or shared with the public, the ideas that lie beneath that specific creative expression cannot belong to any one person, as ideas are not susceptible to the notion of exclusive property. The framers recognized, however, the need to protect specific expressions of ideas. But the framers also believed that the protection of distinct expressions of ideas should not be so rigid and restrictive as to stifle the creativity of new, distinct expressions of ideas. In other words, a balance needed to be reached between the limited protection of specific expressions of ideas of authors, producers of creative expressions, and the right of the public to freely use the ideas that lie beneath those specific expressions. So when someone says that he or she stole an idea, that's not exactly correct, because ideas are not protected by copyright law. What is protected is a specific expression of an idea. In other words, you can borrow an idea for somebody, and what is protected is the way that you manifest that idea.
Funny thing is, though, life don't move at the same speed for everybody.